Welcome to the Voice of Retail. I'm your host, Michael LeBlanc. This podcast is brought to you in conjunction with Retail Council of Canada. Meet Mark Elward, Senior Competition Law Officer at Competition Bureau Canada, with the second of a series of 4 episodes created to help us understand the laws governing and protecting retailers. If you want to learn more about the Competition Bureau and how it operates, tune into the first episode of the series to learn all about it. In this episode, Mark takes us through the law and perspectives around price fixing, collusion, and cartel behavior investigations. Let's listen in now. Mark, welcome to the Voice of Retail podcast. How are you doing this afternoon?
Hi, Michael. Doing great. Thanks for having me on.
Well, fantastic. Now, for my listeners, this is another in a series of episodes brought to us by Competition Bureau Canada with the objective to inform and educate retailers and the retail industry on competition regulations and laws. Now, for those that missed the first episode in the series where Mark, one of your colleagues, told us all about the Competition Bureau itself, I'll put that link in the show notes. So, Mark, you and I can just dive in to more about you and your specific area of practice. Tell us about yourself. Like, how did you get to the Competition Bureau? What's your background? And then tell us about what you do for a living.
Yeah, sure. Well, I'm a Newfoundlander first and foremost, born in a small town called Stephenville. I was raised in St. John's, which as far as Newfoundland goes is the big city. I did my undergraduate degree in commerce at Memorial University in St. John's. And right after that, I didn't waste any time. I went straight to law school at the University of New Brunswick. And when I was there, during my third year, I actually did an elective studying competition law. And that was my first exposure to the topic we're going to talk about today. But before I got really involved in that in that concept, I came back to St. John's and actually practiced there, doing kind of everything that a junior lawyer is expected to do for a brief period of time. And then in July 2016, I got a job with the Competition Bureau, which involved a move from St. John's to Ottawa, which I know Torontonians view Ottawa as a small, boring city, but for a Newfoundlander, small town guy like me, this is the big city. So been here since 2016. I'm really enjoying what I do. I really enjoy the people I work with. You know, I'll get into it a bit later, but my role as an investigator generally involves interviewing witnesses, executing search warrants, doing a lot of document review, as you can imagine, from those search warrants, sure. And basically putting the puzzle pieces together to determine facts with respect to allegations of cartel conduct.
Now, did you so you have both business degree and a law degree? Did you always want to be a lawyer? Was the business degree a path towards business-oriented law, or how did that unfold? Tell me a little bit about that.
Yeah, so my dad was he had a commerce degree, and so no lawyers in the family. So I just kind of did business as a kind of a safe path when you're 17 and going to university.
Sure.
And as I got further on in the business degree, I did a few work terms, had some exposure to some business law courses, and really it just felt like a natural fit. And I don't know, at 22 years old, I wasn't ready to enter the workforce, so I decided that more school was for the best.
Yeah.
So then, that law degree then opened up a lot of possibilities. Obviously, the law firm was the obvious path in the beginning, but then, when I wanted to get involved in competition law, it was either you can work, in competition law in some of the big firms in Toronto. Some other firms do it, but it's mostly based in Toronto. Or you can work for the federal government, which is for my agency, which is the Competition Bureau. So
right.
When I got the opportunity to do that, I decided to jump at it.
Now, in all the discussions that we're having today, I think you've got what would we call it, a disclaimer. So this discussion, talk about how you would frame this discussion with the listeners.
Yeah, I guess that's the lawyer in me being overly cautious, but I just want to say, that that my views here don't necessarily represent the views of the Commissioner of Competition, which is my ultimate boss. And they should not be construed as legal advice. So I know it's a bit of a buzzkill, but I just couldn't help myself.
Well, all right. Well, that's fine. I think everybody's cool with that. All right. Now, let's talk about what your specific area of practice is, this idea of the cartel, and that'll help us unwind what is a cartel in the competition sense of the word, and then we can get further into the discussion.
Sure. And to be clear, my role is as an investigator and not as a lawyer, although many of our investigators are trained as lawyers. What we do is act as investigators. We work with a lot of lawyers, including the Public Prosecution Service of Canada, who ultimately approve or deny whether our charges will go ahead to a formal court proceeding.
All right, let's talk about your specific work, this cartel, and talk about it. What is it in the competition sense of the word?
Yeah, so a cartel, it's a very scary word, but I think it's meant to be, because ultimately it's very bad for the public, for the economy, for the country ultimately. So a cartel in the competition sense is basically an agreement, any agreement between competitors to fix the price of a product or service, any agreement to allocate customers or markets, or an agreement to control the supply of a product. So I know I threw a lot at you there, but I guess an example, if you want to get into that, is basically, gasoline retailers. We get a lot of complaints about gasoline retailers as far as price fixing is concerned. People see that, you have 2 or 3 gas stations near each other with the same price, and they kind of assume that there must be collusion happening there. Yeah, but it's not an offense to price independently or monitor what's happening around you as a business.
Right.
It becomes an offense when you pick up the phone and actually make that agreement with your competing gas station in that example.
Right. So it's a big, and it's a very important difference between market assessments and competitive analysis and this collusion that leads to a cartel. Yeah, that's probably a pretty defining thread that runs through how you look at things. Yeah.
Absolutely. And so I think, maybe if there's any lawyers listening to this, they'll probably, think of the term conscious parallelism, which is a mouthful.
Yeah.
So that, that is when, you're behaving in a way in concert with a competitor, but you've never had a meeting of the minds. You don't have an agreement underlying that. You're consciously, aware of what they're doing in the market. You may be a less powerful competitor and you feel like you need to follow the actions of your competitor. That's all well and good as far as our Supreme Court of Canada is concerned. And as far as we're concerned, because ultimately, again, we need that agreement for there to be collusion. And that's a key piece of our legislation.
Now, let's talk about, and we're going to get a bit deeper into this, because there's also this new idea. I don't know if it's a new idea. You talked about goods and services collusion, but also about people. So I'm kind of keen to get a little bit deeper into that. We talked about that off mic, but let's talk about penalties. Is this a civil penalty? Is this a criminal? Talk about that a bit.
No, definitely not civil. So I think that's something that people do confuse. They're confused about our role, and they kind of view us as almost auditors or something when we come in for our search warrants. But no, it's a very much a criminal offense. It's an indictable offense. It's one of the most serious offenses in the criminal code. Short of the violent crimes. So our legislation in the Competition Act. I said criminal code, so I should have said the Competition Act is actually where the offense lies, although we do use criminal code provisions to assist in seeking search warrants from time to time. So really this legislation is in the Competition Act. That's the main legislation we use. It provides for up to 14 years in prison for individuals who engage in the offense. And currently there's a $25 million limit for the general conspiracy provision. And that's the conduct I was talking about there with the agreements between competitors to for example, fix prices. Now,
how do you uncover these? So, talk about investigative work, and is there the second kind of part to that is are there whistleblower programs or that give immunity? But talk about the investigative work that goes into discovering or uncovering these alleged perpetrators.
Yeah, so we have what's called an immunity program. And that, I would say that is our most important tool for uncovering cartels. Basically, you have to remember that these cartel agreements are secret agreements. It's not like people are broadcasting these agreements. These are usually...
no social media. There's no social media posts on LinkedIn about it. Hey, I just did a great deal.
It does happen. I've seen it before where there's, there's a public group where there's businesses agreeing. Usually very unaware of how illegal that conduct is. And I guess that's probably the reason why I'm here to kind of explain this. So really the immunity program is really critical for us because the agreement is usually secret. It's important for us to have people come forward that are actually involved in the agreement. So what we do is we try and create a race to the door by offering full immunity from prosecution to the first person or business, sometimes both, that come in and tell us about an offense. And also, that involves significant cooperation from them as well in order to get that immunity. So we try and kind of incentivize that cooperation. And then
I love that term, by the way, a race to the door.
Yeah, well, that's the idea. And I think, it's been around for about 20 plus years. I think the Americans had it first, but been a very effective program. And, when people understand that they can avoid that prosecution, I think it can be a very useful tool for us to get people to cooperate. And similar to that, we have what's called a leniency program. So basically, if you miss that race to the door to be first, you can still come in and cooperate and get a reduction in fines at sentencing.
Right.
And so it's called the leniency program, and that works right on down the line. So let's say you have a cartel involving 6 competitors. You got the first one came in for immunity, and then you have 2, 3, and 4 want leniency. Well, the second person there in line will get the biggest reduction in fines usually, and then it'll get less and less of a reduction as you get later and later in the door.
Now, once you begin the work, so you as you said, you do a lot of reading. It's certainly, you don't need to be a lawyer, it sounds like, to do your job, but it's kind of helpful. That kind of appreciation and understanding of documents and where they come from. Now, as you dig into these cases, talk about the actual work you do to prove a cartel case.
Yeah, I should say that, so we're not all legally trained. Some of us are. We have a lot of economists as well that also work as investigators.
Oh, interesting.
And I think more and more we're hiring more from from law enforcement backgrounds as well, because ultimately, that's what we are. We're investigators. We're dealing with criminal offenses. So we have but that's usually the background is those 3 buckets with some exceptions for sure. As far as actually proving the case, so we have these cooperation programs, and I neglected to mention the whistleblower program, which is similar in nature, but it basically provides protection to an individual who's aware of an offense, and it basically prevents them from being fired on the basis of them reporting that to us. And in addition, we provide confidentiality guarantees to those people, so their identity won't be revealed.
Now, I almost hesitate to ask you this question, but are there any examples that come to mind around that you can give us, just to flesh out some examples, something that's happened in the past that you think would illustrate the cartel in the retail industry, or any industry really?
Yeah, and so I think because this is done through the Retail Council of Canada, I think something involving retailers would be useful. And I think the gasoline price fixing case. So I did talk about gasoline price fixing in an example where in my example it wasn't happening. Now this is a case where it actually did happen, and it started way back in 2004, and the last trial actually just finished taking place in 2019. So these things can drag out, as you can imagine. As the various kind of steps in the justice system have different timelines associated with them. But in that case, there were media reports of possible price fixing, and ultimately our investigators were able to obtain wiretaps from the court to listen to phone calls between gas station operators. Huh. And they found that they were calling each other to agree on price changes in the gasoline industry. The case started off in Victoriaville, Quebec, and then it turned out that the investigation revealed that there was the same kind of conduct was happening in Pepper Mines, Magog, and Sherbrooke along Quebec.
Now, you just said something interesting, that there was media reports. Is that something you guys keep an eye on? Is some investigative media that I guess is one of many things that kind of raises your attention? But it's interesting. Is that how that all began?
Yeah, it is. And so basically, I think in the media report from back then, again, this is before my time, so I'm going based on what others have told me, but I understand that there was another gasoline station operator had, basically alleged via the media that there was that these agreements were taking place. So no hard evidence, but we had somebody who had gone to the media and said, look, there's something going on here. And that's enough to start a case for us. We can get calls from the general public. We have an information center that takes in complaints from the public. Yeah, media reports. We also, this is not so relevant for your audience, but we investigate agreements to rig bids. So, agreements between, let's say, for example, two competing construction companies to decide who's going to win a public tender. So we'll often work with the provincial governments or municipal governments or other arms of the federal government to see what's happening in those industries.
So I've got I would say a fairly diverse group of individuals listening to the podcast, as you would imagine. So there's some people, no doubt, listening that are very steeped in this, very experienced. The larger retailers would have expertise, lawyers, whatever. Many retailers would not, but they'd be familiar with the ins and outs enough that they would know day to day. But, where I wanted to take this has been great discussion, is any changes. So no matter who you are listening to this podcast, are there any changes to your area that people need to know about? Because I think you indicated there were, and I'd like to dig into that a little bit, just so maybe you're an expert in it, maybe not. But there's new rules. There's always new rules, and we don't want anybody to get tripped up by those, right?
For sure. And I think there was a significant round of amendments to the Competition Act that happened actually in June of this year. But the criminal provisions won't come into force until June of 2023. I believe the date is June 23rd, 2023. And the reason they do that is to give businesses and people a chance to sort of understand the new provisions, become aware of them. And then, in larger businesses, of course, there may be additional compliance training that gets rolled out. I think one of the key changes there, one of them I already kind of went through, which was the removal of the cap on fines for cartel conduct. But there's also the creation of a new offense. So this is the so-called kind of wage fixing / no poaching offense. And so what it does is it prohibits employers to agree with one another to fix the wages that they're going to pay their employees. And it also, that also applies to benefits. So conditions of work. Now it's a criminal offense for two employers to do that, and it's also an offense for them to agree not to solicit or poach one another's employees.
So to be clear, it's not an offense, though, to do a market scan and find out what average wages are, right? That falls into that first part of our conversation where there's a difference between colluding together, picking up the phone, and just doing a market scan, maybe by a third person or maybe under an association like RCC. Am I getting that right?
That's exactly right. Yeah. So really, again, it's the same as the regular, cartel provision, where you need that agreement, meeting of the minds between two employers. So again, you just can't have two employers get together and say, look, you don't hire my employees, I won't hire yours. Because you can see how that may be tempting to try and protect trade secrets. But it ultimately is my take on this is it's a significant harm to competition, and it really harms the workers' ability to market their services and to get jobs. And so it really controls the job market through, again, this secret cartel arrangement. So that's kind of that's why I believe they made it criminal. And again, that won't come into effect until next year, but I think it's a good move.
Mid-year next year. Now that is different because I think it's under maybe it's under provincial, because I think Ontario passed this around non-compete agreements in your labor agreements, right? We're talking about something different here. Just so most people would be more familiar with that, right? So that's a different thing than we're talking about here, right?
Exactly. Right now, we're talking about that kind of, you think about it at the same level of the supply chain. So you're talking about two employers meeting together and never really involving the employees. This is the kind of stuff that's now become illegal in a criminal sense. The stuff you're talking about with the Ontario changes, these are clauses in individual employee contracts with their employer that often the employer may put in they may put in a clause that says you cannot compete with us if you leave. Those are the provisions that I believe the Ontario changes were aimed at. So our legislation doesn't deal with that. That's something that the provinces deal with. But whereas the wage fixing, no poaching stuff I'm talking about, this is kind of this horizontal conduct agreements between employers. That's the stuff that it will become criminal as of June next year.
Okay. Now, we've given a lot of information. It's been a great discussion because hopefully, we've talked about it in such a way that it would kind of either clarify or raise enough questions for people to want to learn more. Where can listeners go to learn more? Like many retailers might not have their own legal counsel or want to, hire outside counsel, but is there resources on the government's website, or can they even call people like yourself when they have questions? How does that work?
Yeah, absolutely. So the website, I think, is probably the best first stop. There's, all kinds of information about our, immunity, leniency, whistleblower programs. That's all online. Yeah, obviously, as far as, I did mention that we have this portal to submit complaints. And we also have something on our website where you can request an outreach presentation. So you can request someone like myself to kind of come by and educate. It could be your business, could be a business association. Most of the time I do them with procurement authorities, so that I can kind of teach them how they can avoid becoming a victim of a bid rigging cartel. But
how to recognize it more than how to recognize it, so to speak. Well, that's great. Listen, and this is a great resource too. So it was a great conversation, Mark. I want to thank you for joining me on the Voice of Retail and helping educate the community on this area of competition. And I want to thank you for your service, and then thanks for coming on to the podcast and chitting and chatting. And we look forward to continuing talking to your colleagues in this series. And for now, I wish you a great rest of your day. And thanks again for coming on the podcast.
Well, thanks very much, Michael. I appreciate the opportunity.
Thanks for tuning into this special episode of The Voice of Retail. If you haven't already, be sure and click and subscribe on your favorite podcast platform so new episodes will land automatically twice a week. And check out my other retail industry media properties, the Remarkable Retail Podcast, Conversations with Commerce Next Podcast, and the Food Professor Podcast with Dr. Sylvain Charlebois. Last but not least, if you're into barbecue, check out my all-new YouTube barbecue show, Last Request Barbecue, with new episodes each and every week. I'm your host, Michael LeBlanc, president of M.E. LeBlanc Company and Maven Media. And if you're looking for more content or want to chat, follow me on LinkedIn or visit my website at meleblanc.co. Have a safe week, everyone.